Good afternoon to you. I'm very glad that we attracted an audience as large as this, so legal issues cannot be that dry. And I have the honor I'm Stefan Skopin from the Berlin University Alliance. Welcome to Berlin as well from my side. First of all, I would give a very short introduction, then I immediately hand over to Katja Meyer there on the right, who will moderate the session. And then afterwards, we have time for Q&A, and also you can then use Slido. Thanks. First of all, we are latecomer to the conference in the sense of that Katja and I saw there was still a slot, this one open, and there was no name, no panel, and then we approached the program committee to wouldn't that be an issue, that is a word of discussion, and then they said yes, and we got a wonderful panel together. And so thanks for accepting the panel after the deadline, and also thank you to Federico and to Savani for helping us through the process, Sylvia as well. So I want to make a use case why this is also important for universities. I work for the Berlin University Alliance. We unite 3 universities and a university medical hospital, and research data becomes more and more important. What we don't have in Berlin is a legal help desk. So our libraries are mostly lawyers. No, there are no lawyers who have like some expertise in all the legal issues, but it becomes more and more confusing. So the use case I would like to make is how can I orient our researchers and our research provision staff to give like good legal advice in an environment that's becoming more and more complex. And I think that a legal desk alone for the Berlin area will not help. We will also need like the content clarified. So this is like a very prominent like challenge for us as a university to provide this orientation. And as I say that accessible data, be it like in the FAIR mode or on other modes, becomes more and more important, becomes like the new goal of this environment, of this century. And it's also shaped not only by our local or regional laws, by our national laws, but also by the European laws. And that's why we have this panel to discuss some of these topics today. Katja and I know each other because Katja is one of our Open Science Fellows for this year, and she comes with her expertise from Vienna, a broad expertise in different subjects of open science. And now I'm very happy to hand over to you. And I will again remind you that you can join the discussion in Q&A in person here after the panel has its first round, and then you can also use Slido. If you use Slido and you feel we invite you not only to pose questions, but also to make claims that we can follow up on in future discussions. So I hand over to you, Katja, and have a good panel.
Yeah, thank you very much. Thank you to you all for coming here to this session. We'll have about half an hour of discussion at the roundtable, and then we open the floor for the Q&As. I welcome our discussants today. Irene Schlünder in the middle, a lawyer and expert in EU data protection and database governance at TMF. Today here in our round, representing the legal perspective of research infrastructures, drawing from your extensive involvement in BBMRI, the biobanking infrastructure. And to your right, I welcome Kaspar Droszewski, who is a senior researcher at the Center for IT and IP Law at KU Leuven. You are specializing in digital regulations and have been part of the team that was conducting one of the studies that our third panel member today, Michael Arentoft, has commissioned, among many others. Michael, you are the head of the unit of Open Science and Research Infrastructures at the European Commission's Directorate General for Research and Innovation. And from your side, I think you'll add more to the perspective of the policy makers and the funders to the discussion today. So also, of course, we'll talk about a recent study that has been commissioned a bit later. And we directly jump into the discussion, I would say. But before, I would like to just briefly clarify what we mean by data cycle or along the research data cycle, because I want to ground us in the reality of data practices. So a lot has been said about publications already, but in the context of EOSC, the focus shifts to research data and maybe also to many other types of research output. So today it's all about data and their environments of practice. And all these things that these cycles include, like data creation, analysis, storage, sharing and reuse, and preservation. And at each of these steps, a lot of legal and many other challenges arise, particularly around access, licensing, protection, security, and some other responsibilities. And so one key issue that keeps popping up in my own research, but also in a study that a colleague of mine, Shiga Skorjanc, has conducted on Austria's open science legal frameworks recently, is the persistent confusion around what is often referred to as data ownership, a term being used to denote anything from property, you know, what can I do with my data, to responsibility. So many researchers remain very unclear about whether they can open their data, and by the way also their software, because the topic came up yesterday as well, and whether or who holds the responsibility for it, for example in the liability of data quality, for data quality. So they do not feel very informed if they can take their data with them when they move institutions, for example. So, Irene, I would like to start with you. Is the question, who owns the data, really the right question to ask?
Now I give my favorite response. It depends. So let me start with the opening statement that law is becoming more and more complex. I think law has always been complex. So my favorite answer indeed is it depends. And as we all know, law is about balancing, so we can have even different opinions. So we might end up with, 2 lawyers and 3 opinions in the end. So let me start with my standpoint. Data ownership can make sense, but it has different meanings. First, there is ownership is a very technical legal term. And there's a definition, and from that perspective, I would say, no, there's no data ownership. You don't own your data in the sense you can own your house. But ownership also has a context from more colloquial language, and that relates very much to the concept of responsibility. And there, yes, there is data ownership in that respect. So as we can talk about project ownership, that doesn't mean that I own it like my house project, but I'm leading it, I'm responsible in a way. And this is also the case regarding the data, let's say on my computer in a way, or in my system, or the data I have collected. And the responsibility very much depends on the kind of the data. So there's one regime, and when we talk about data security, maybe we come to this afterwards, it's mostly about personal data. So in health research, for example, we are always dealing with more or less sensitive data, and there's a responsibility on it, of course. And that comes from the actual control of the data. So it's in my system, it's on my computer, and I have collected it from somebody who has trusted me that I will deal with it in a, let's say, secure, in a trustworthy manner. And there is, in that sense, ownership. So it gives me more responsibility than it grants me rights in the sense of copyright. And there, the legal discussion starts. So from my perspective, I'm a little bit of fundamentalist here. No data have no copyright. There's a database where you can acquire a copyright, but this is more the structure. So copyright always requires that you have put an idea or some brain effort, so to say, in something, so a creation, and data are just collected. So as soon as the data are out there, everybody can use it. Maybe that's my statement so far. Thanks.
That's of course, a radical thought that a lot of researchers have not been thinking through, I think, and also maybe feel, as far as I know it from the interviews that I did with researchers, have not been informed about very well. But you mentioned several aspects of data ownership, I think, which is quite important for us, what it means to take ownership in a sense of responsibility. But also you mentioned that there is, for example, different layers of IP, if you like. Please correct me, I'm not a legal scholar if I say the terms in the wrong way. But there is, for example, the copyright, the copyright per se, the authorship, and then there is, of course, also all the different licenses that you can give for different sorts of uses, right? So these things are often confused or conflated with each other, I think, and this is also a problem in that regard, because even if there is no ownership on data, or no, this doesn't mean that there is not licenses that you can put on that to reuse it, for example, or share it, right?
The fact that you actually control the data means that you can, of course, define or determine the terms and conditions on how you share it. Even if there's no copyright, of course, you can conclude contracts. So as soon as I transfer the data to you, you are bound to my regime of how to use it. And this is, of course, possible. And then this is a contractual obligation.
Yeah.
This is not a legal obligation stemming from copyright law. It's just a contractual obligation. Of course, this is doable. I mean, you can do that. And this is what many even statistical agencies do. You have to pay a fee, otherwise you get not access to the data on an actual level. So this is something which you can do. But this is distinct from the fact that, code, for example, or something created has a copyright. So wherever you find it, you're not able to use it. And this is different from data to, let's say, intellectual results and intellectual property.
Yeah. But I think there is confusion on that, and we kind of meet that in a lot of different contexts. But when it comes to copyright, in the recent study that, Caspar, you and your team contributed to, the authors examined the opportunities and challenges that researchers face, for example, with not only the many day-to-day problems, legal problems, but also in regard to copyright. And the question is, and I think this also, of course, in remembering what has been said yesterday also about EOSC and the development of EOSC, where there will be a lot of resources maybe to help with legal compliance and open data principles. But there are so many challenges, I think, that still remain around these topics of IP and copyright. So, for example, there is now a lot of exceptions when it comes to copyright for research purposes. And how are those exceptions handled so far, right? And I was wondering whether you can give us a little bit of insight in that, and also, of course, thinking about your background in consumer protection and power asymmetries, what you think about these kind of this approach to handle it with exceptions.
Thank you very much for this question, and thanks again for the invitation. This is a provocative question. This is the best kind. Also because Katja knows that at heart I'm a minimalist in many ways, and copyright is no exception. But first, I wanted to react very quickly. I promised I would stick to 5 minutes. So please shout at me if I overdo it. On data, there's a data ownership. I'm afraid that and by the way, I agree, we should be talking about access and control. We shouldn't be talking about ownership unless we mean it in the Marxist way of ownership of means of production. And then it becomes a completely different discussion, which we nonetheless should have. But this is a different discussion indeed. A lot has been already written about the discussion on data as property, and you cannot own copyright in facts and data, as rightly said. But on a practical level, we are behaving like like it exists, and our lawmakers, our policymakers are no exception. This was already we already saw this as in the discussion when, and I'm actually hoping for a counter on this. If you remember when you may remember the discussions about the sui generis database right. It faced heavy criticism from many academics, including Professor Margoni, Professor Kretschmer, when they were pointing out that this is throwing out of the window all the intricacies of copyright, the idea, expression, dichotomy, the looking at what is facts, what is data, all that goes out the window because now you get protection in a database, and when does data in practice exist outside of a database? That's a rhetorical question, by the way. And then we had the discussions on the Data Act, which when the proposal was first released, it was hard not to get the impression that it solidifies a presumption of a sui generis ownership-like right to data that data holders must be enjoying, since we are granting exceptions from it. So again, whatever we call it, clearly to many people, this is what it looks like, and we can talk about data, about access and control, but if you do look at it from the political economy perspective, the question is very valid. And I'm really tempted to now start talking about the question is about exceptions. Exceptions are meant as a safety valve. They're supposed to de-fossilize the market. They're supposed to help the runner-up achieve market entry when rights holders are already occupying the market. When Google was in court with publishers, Google Books was seen as the disruptive innovation, and that was the innovation that was trying to achieve market entry against an existing system of rights. Now we live in a world which is run by data-based services we don't understand, although we agree to their terms day in, day out. We no longer read these terms. We don't read the privacy policies. And with every day that passes, we are more and more in a world which we consent not to control. However, that world is doing very well at controlling us, as we see in all the discussions, all the studies about impact on the democratic process, on democratic societies, and the reallocation of power in new societies. So the question to ask ourselves would be, where does the power to innovate lie? Who holds the keys to innovation, in the words of the US Supreme Court? And where do we want this innovation to come from? And then we should look at our system of exceptions, which by nature are limited and circumscribed and need to be interpreted strictly. And then we should ask ourselves, do they serve the purpose? I think I'll stop here, but I'm happy to continue.
No, perfect 5-minute answer, actually. I think, you opened the question up in a very big way, but you also pointed to a very good bridge to bridge now to you, Michael, because as you say, we need to look what exceptions are there and who do these exceptions serve, and how regulation is actually also overlapping in that regard. And I think until recently, what has absolutely missed was an overview about all this regulatory complexity that is out there. And thanks to Michael, your team's dedication to this topic, and maybe also, of course, in the background, the wish for better regulation and more efficient regulation, there have been several studies until recently that try to look into this complexity to, first of all, start seeing where are those things that need maybe some tweaking because they are not maybe running the way they should, or they are even some kind of paradox, creating some paradoxic situations because they don't say the same things. So with your experience now based on these 5 studies, which the latest is called, I noted it down. Where is it? Which was done to provide key evidence for the priority 2 of the European research area actions, but I forgot where I put the name of the study, but I'm sure you can help us out because it's online and you all can have a look at it. And for me, it was really mind-blowing how in one piece, a long piece of text, of course, but still, you managed to bring all these different complexities together on a very understandable level and showing us where there is actually now need for action. So we're now talking a long time, but my question would be to you, learning, what are the lessons learned from these kind of look into the regulatory complexity, and what do you think are now the key aspects that need to be harmonized or prioritized also for questions of compliance? And also, what are the new opportunities that come with exactly not only the regulations themselves, but also now the insights you have across the regulations?
Yeah, thank you. First, I wouldn't like to take credit for this. It's the study team in which Casper was one of the contributors. We commissioned the study. We looked at, we asked to look at 9 different pieces of legislation, which is not complete. It doesn't include the GDPR. It did not include the European Health Data Space Regulation, for instance. It included on the copyright side the Database Directive. You made reference to it already. The Copyright in the Single Market Directive, and also the Infosec Directive. On the data side, you already made references to the Open Data Directive, the Data Governance Act, and the Data Act. At the time of the study, it was still in proposal stage. And on the digital side, the Digital Services Act and the Digital Markets Act. And we also included in the very last minute the AI Act, again, which was under development at the time. So the study team did a great job, and you can see the report that we released in May. And indeed, it gives this a very excellent overview of, in particular, of course, the exceptions. So, of course, we have copyright exceptions that do exist for the purpose of scientific research, but they are mostly non-mandatory, very importantly, and also they all have some kind of limitations in scope. So a very important part of the study was to do the surveys. One thing is to get a nice overview and trying to have some clarification. Another one is to ask those who now need to comply with this, the individual researchers, the research organizations, but also the rights holders. So we were really trying to be complete in asking all types of stakeholders, or you were, sorry, the study team. Because first of all, it creates fragmentation, the fact that it's non-mandatory. And secondly, it creates legal uncertainty for our researchers. Hence the confusion also on many aspects, starting maybe with the ownership. And that's very important because they need to know what they can do and what they cannot do with the works of other research teams. So they absolutely need to know who owns and controls the data. They need to know how it can be used, how it can be shared. They need to know who can access and who can reuse what data, for which purpose, under which conditions. And of course, there are legal experts sometimes closely to the research teams, but there also must be some at least basic level understanding to ask the right questions to the right people. We also looking at the digital legislation, which was relatively newer, in particular for the Digital Services Act. The Digital Markets Act apply less. I would say it's less relevant for the research sector. But the Digital Services Act, actually, you have to know as a researcher what are the conditions very clearly under which large platforms are to share data with you for research purposes. So this again, we now looking at your second question, which is, okay, this is what we have learned, and it's not all. It's a very comprehensive study, although not completely. What we can do about it? Well, the first obvious one was to look at, could we make these research exceptions mandatory? And what can we do from a policymaker point of view, and of course also funder, to clarify what is already there? So you already mentioned some of the questions that researchers ask themselves. Can I take my data with me? But also what copying of documents or digitalization of documents can be done by an individual researcher? Often questions we heard. What data sharing can I do as an individual researcher? And also looking at it from an European level perspective, so the cross-border perspective. I mean, nearly all teams that work on a research project, they work cross-border. So what happens if in different national legislations you have applied the EU legislation in different ways? What if you have a partner in one country that can do something on processing your data or storing your data that cannot be done by another partner in the same consortium? So here, can we from a European level do something to harmonize that in a cross-border consortium? On the other aspects, it's very much a question also of clarification. And our colleagues in DG Connect have already started to do that. So, for instance, recently there were, September last month, there were frequently asked questions around the Data Act. So you can go and Google FAQs on the Data Act, and you will find a number of clarifications there. It's not complete also, and we want, again, to add more from a research point of view. The same thing with the Data Governance Act. There was what was called a practical guide to the Data Governance Act. Again, we are working closely with our colleagues in DG Connect, who are leading, of course, these pieces of legislation to make sure that from a researcher point of view, things are clarified. And also things are made easy in the sense of reducing admin burden. So if you want to request a data set, the form that you need to use should not be too complicated. So here also, all the way down to the practical level, we work on different options in terms of also non-legislative measures, because in the day-to-day practice, this is what counts for the researchers.
Thank you very much. I think, Irene, you wanted to add something here.
Yeah, I'm still not totally happy to talk about exceptions to copyright, since, as I've stated, at the beginning of the session, I do not see any copyright with respect to data. What I see are upcoming obligations to share, and there, we are facing this. We are facing health data spaces. I'm closely working now on the implementation of the upcoming European health data space. And there you have clear obligations to share. This is something else than an exception to something that was prohibited before. I do not see any prohibition to share data. If you want to share, please share. There's another regime that is very important, and this is GDPR indeed. So you cannot share personal data. You have collected while promising, maybe even, on the basis of consent, for example, or on a contract, while promising that you would not share it because it contains personal information about certain individuals. But on the copyright side, I really do not see any prohibition. But, of course, and the Data Governance Act is about it, I mean, I find it even from a political point of view correct to say there's an obligation to share, mainly in those areas where the data have been collected on the basis of public money. public funding. So we have, even there, sometimes open licenses for IP protected, let's say code or databases or something, but also data collections. I mean, you can block it as soon as you control data, you just say, I don't share. Even if there's no copyright, and this is, and I totally agree with you, a political issue. So that's why we have started to adopt these legislations to make it obligatory to share data under certain conditions. And the conflict I see there is the conflict with GDPR, and this is what we are working on now in the EHDS implementation. Yeah, on the one hand, you have the obligation to share. On the other hand, you maybe collected the data on the basis of consent and you promised not to share. How do we reconcile that? This is not so clear, and even on the basis of legislation, it's not so clear what to do with the data we already have in the systems.
Yeah, Michael, you want to respond?
Maybe just a reminder of how this whole priority action under the European research area started. It started because we saw researchers being forced to give their rights away when they wanted to publish in prestigious journals. That's how the whole thing started. And then it was expanded to data legislation and digital legislation, and asking even more questions. And here, effectively, you could imagine, and this was one of the key outcomes of the study, to have a secondary publication right. Not an obligation, but you will have the right to publish a secondary time in an open access venue. Oh, it's not the discussion of this forum, but it's an example of where you, because there's public money going into it, you could give the right to those publishing to have a secondary publication.
Mm-hmm. So historically, that's also maybe explaining a bit why this idea of exceptions became bigger. But I wonder, because Irene, you mentioned you shifted our focus a bit to the question of obligation. And I think this is a very interesting point that we have probably not enough time to discuss before we start the Q&A, but just maybe briefly what I want to mention here is with the obligation to make data reusable and all the problems that you mentioned, informed consent being one of the biggest, I also see that, the question is what are then new responsibilities for the research infrastructures and organizations. And I think this is very relevant to EOSC here. And I think there we are maybe also just in the beginning of understanding what really comes to the research infrastructure organizations as well, right? Would you agree here?
Yes, there are many obligations.
Yeah.
We heard it here and there. Mark Dietrich to refer to it, so be aware. You have to deliver metadata in a certain format, DCAT format. You have to do things and costly things. So just if you do your calculation on projects, take that into account. That would be my advice.
Yeah, I think, I don't know, does somebody of you want to add something here? Or should we start the Q&A? Because from the time I see that we are now obliged to start the Q&A. And I was wondering whether, we can show the Slido. Oops. Ah, yeah. No, that's not us, right? There are already questions. Yeah, I'm a bit slow, sorry, because yeah. So Stefan, you want to pick out a question for us?
I would give preference to the...
Oh, yeah, sure.
So there's the first one.
Thank you for the introduction and the roundtable. I have a question for the panel about creativity on data. So we made very clear at the beginning that there is no copyright on data and data are facts. I'm asking you, if I'm registering, for example, the temperature outside with a new prototype, the creativity part will be in the developing of the prototype to register the temperature, and the temperature is there. So while if I'm preparing an experimental setup with a new instrumentation, also the way to measure the data that I'm going to acquire with the instrumentation will have a specific, let's say, something that I put on the setup. So how do you see this about creativity on data?
Who wants to answer? I just need to clarify that we didn't say data are facts. We need to be very specific on that, because maybe I misunderstood you, but I think we didn't mean that it's like the same as facts or something. Yeah.
I can try. So my question would be, it depends a little bit, you know, you have to discuss really in depth. But my first answer would be, so the whole procedure, everything is copyright protected, so can even be patented in certain ways, I don't know. But the result is a mere information would again be not protected. We can discuss, of course, and we can even discuss to change the law. I'm not here to tell you, you know, it's my conviction that it has to be in the future, but then I have to tell you, go to Parliament. I'm the little lawyer, I'm applying what's out there, and still we have no copyright on data, even if it's generated with much effort, with much funding, with much creativity behind the scenes. So, but maybe we can develop something to change it a little bit. So let's work together then. But if we are talking here about, you know, we need to make it more open, maybe it's not worth the effort to make it more prohibited or closed. I don't know. It's a political question.
Well, this is, of course, a fair point. At the same time, can we envisage such data existing outside of a database that would not merit the protection under the sui generis right? Yes, please, go ahead. No.
We are going towards, you know, really legal questions. So there's a question out there, and I even don't know. Normally, I'm more the data protection specialist. So now IP rights is something of my professional past. So if something has changed, please advise me. But it's an old question. The database protection covers the data in the database. And as far as I know, there's a no so far. But if that has changed by any decision, I don't know, please advise me.
I think, sorry.
Yeah. Please go. Yeah. Just, no, please go. Give a short answer, and then we can move to the other questions. I think that's an important question.
I think we should collect some questions.
Okay, then. Okay, but we keep in mind, because this is a question that comes up very often.
Two lawyers, three opinions.
Yeah. The database and the data. If the data can exist without the database. Where?
Two questions. First over here, and then.
Thank you, Roxana Wilk from Cyfronet in Poland. Just add to the discussion, to the academic, it's an insight. I'm not even certain if I care if I have the copyrights over my data in the end from the practitioner perspective, but I imagine the argument that maybe the data itself is not creative, but the structuring of the data, whilst I put my thought into how I structure it for the sake of the reuse, this is the creative part. So for the discussion in the future, I think you might be ready for these kinds of arguments. But what I wanted to ask you is something totally different, because I'm a total noob when it comes to legal issues, which might be troublesome, because I would like to deliver a platform where people do exchange data on a normal basis. For nationwide, for example, we would like to have this kind of aggregator of data, but right now, who collects the data is the institution, the scientific institution. This is why also I was quite surprised to hear that there is no ownership of data. I was certain that the institution has the ownership of the data, but I will take the knowledge with me now. Nevertheless, I would like to create a kind of a marketplace for the data exchange, where people, scientists, are putting their own data and they do control it in a way for make the process lightweight. I'm starting from the user perspective here, but again, legal part is not my strong part. So if I want, in fact, have in the future this kind of a platform when I come and publish my data and then make a reuse of it and other people's data, from the legal perspective, is it feasible right now, or there is like 20,000 problems I will need to overcome from the service delivery perspective? What do you think? Am I even close to making this happen or not?
I think we collect one other question, and we keep this question in mind, and also all these legal offices and desks that we'll have in the future. Yes, please.
My question is clarified on the basis of the answer.
Okay, but there is one more. Yeah.
Jacques from Utrecht University. My question is, at our university, we're currently using mostly informed consent as our legal basis for most of the research. And of course, we want to maybe start moving towards using public interest as being our standard use of it. Of course, there's still some discussions going on that, well, informed consent should not be used because it requires specificity, which means that the reuse, therefore, is going to be limited. And that public interest would be better for that sense, but that public interest, maybe not all research will ever fit in public interest, or when does it actually fit? Does the panel have an opinion on this? Is there one that is preferred, or should it always be, depends on the case?
So, yeah, so we have mainly two questions, I think, for the moment. Is there one more? Yeah, one more, but then that's the last one for the moment, so there's
And
no...
we have one more.
Yeah, and one more here, so we have to, yeah, we have only short time. You need a mic? I can give you one.
So what would it take us to actually sunset the database directive? Because in our case, I come from immunology, this directive really hurts our community because it allows certain entities to basically continue or maintain IP protection in perpetuity and by threatening litigation to smaller research projects due to the rather broad definitions. And apparently the court decisions by the European courts are getting more and more inconsistent in this regard. Most EU regulations seem to have exceptions for this regulation. Nevertheless, it was basically continued or not touched upon during the copyright revision most recently. So what would it take us to sunset this?
Okay, so but now we have one more. Do we have? I can give you one mic.
So it's a bit of ad vocem and a question at the same time. It's about European health data space. As always, this is the only thing I can talk about. And it's about what you said before about the fact that there is the obligation to share the data. Of course, health data holders under the current text from the most updated one that we can have, it's from 24th of April. And technically, of course, health data holders are obliged to share the data. But now there is Article 33A, which describes a little bit what happens if health data holder claims that they have intellectual property rights over datasets, data they hold, or trade secrets, which I think we didn't discuss in detail much, but it's a very important component. It's not IP as such, it's quasi-IP, as we can say. Or there is one more thing, but maybe for the discussion it's too detailed. The procedure right now, it's a little bit as in Data Act, I would say, in the sense that it's no longer court who decides, for example, that the trade secret was properly kept as a secret, etc. It's health data holders, obligation to say, okay, this data set is covered by, it's my trade secrets, it's protected by IP, and therefore I'm not really willing. Probably it could be better to not to share it or something like this. And it's on health data access bodies, so the public sector bodies in member states, for those who don't know the upcoming regulation, who will decide whether it is possible, and there comes my question, whether it is possible to properly to protect the IP or trade secrets, to have relevant organizational, technical, or contractual arrangements or measures between health data holder and the future health data user to protect IP over the datasets or trade secrets. So currently this is the case, and the problem is that whenever I talk with people about this, nobody really knows what they mean by the technical or organizational arrangements on like how to share the data, still keeping something a trade secret or protecting the IP. So my question is whether you know maybe some practical example on how to actually do this, because one more thing. Yeah. If health data access body decides that it's not possible to do it in a proper manner, health data holders don't have to share. They're not obliged anymore to to make the data available. So this is, yeah.
So another question in terms of obligations. We had quite a lot. Who wants to start with Irene or, I don't know, Michael?
I can make
Yeah.
it short for
Yeah.
the first one. It depends. Just check all your legal constraints coming from different ends. Check if you have personal data, then check GDPR. Are you allowed to share? This is a regime where you can really be obliged not to share. It depends on if the information is about individuals out there, so patients, for example, in the health data space. But even if this is not personal data, check your employment contract. I mean, you're totally right. Normally, your institution owns the data, in the sense controls it, because if you've collected it on behalf of your institution, you are bound by your employment contract. So if you have something that you have to keep it confidential, that you cannot share, all your secrets, whatever, including the data, then you cannot share. It depends on different layers, so that it depends really. Second, informed consent, GDPR, my favorite. What was the question?
Informed consent.
Public interest is not enough because that's under Article 6 and you need 9 for health data, for example. If it's only personal data, then try it. Go for it. It depends a little bit on national interpretation, what it means, public interest, legitimate interest. Try, go to your legal officer, your data protection officer, go to your national data protection authority and try. But as soon as we are talking about health data, then it's not enough. You need something under 9. This goes, no clue. And a response to this, just as I know from the political background, I think it's not about IP protection of the data. It's about possible patents. For example, coming to EHDS, so behind there is pharma industry and medical device industry. And I would take it seriously. I mean, I'm a little bit, in a battle with industry, always telling them, okay, you want to have the data, but you don't want to share. On the one hand, it's true. On the other hand, they invested much money in collecting the data. A clinical trial is a hell of a cost, wave. And this is true, even a consent form where you describe your protocol too detailed has in certain cases led to deny a patent afterwards, after 20 years of research. So even a data set, when shared, can provide some conclusions about what your research is about, and this is to be protected, and I think their industry has a point.
Mm-hmm. Yeah. Michael, please.
Well, difficult to add because these were very precise answers, and indeed it depends. We also try to have an overview of who controls it. So it's really 50-50 across the countries. In 50% of the cases, it's individual researcher. In the other half is the organization of the researcher. Of course, all the considerations are exactly what it depends on. The EHDS, I don't know the details as you know them, but on your question, what would it require to sunset the database directive? Well, before deciding on anything, you need to make a review. Part of the Data Act made a very limited review of the database directive, which dates back from '96. It's very old. There was the ambition to have a much broader review of the database directive. In the end, it was just singled down into Internet of Things data, and we argued from our side that it would be appropriate to have a more extensive review of the database directive and see what could be done about it. I don't know if it would be sunsetting it, but at least to, as part of the review, to make an amendment to the legislation.
Kasper, you want to add something?
Yes. So first thing, I need to clarify about the study that keeps coming back. Unfortunately, I was not yet on the team when this was being drafted. I was still in Brussels working on digital asymmetries when the colleagues were working on the study, and I saw that we had a question about the name of the report. It's called Improving Access to and Reuse of Research Results, Publications, and Data for Scientific Purposes. And I think it was published in spring this year, May, if I'm not mistaken. Of course, it's Improving Access to and Reuse of Research Results, Publications, and Data for Scientific Purposes.
I'll find it on the publications website from the Commission.
Yeah. So I want to come back on one of the questions that resonated with me. You mentioned how the database right is being used to effectively prevent access, because theoretically we have a limit of 15 years on databases, but if you keep adding new items to the database, you can if you keep republishing the database, it essentially never ends, and the court rulings are being inconsistent. To me, this is a textbook example of where seemingly straightforward legislation leads to inconsistent case law. This is the argument that I also made in my book, which came out earlier this year. Sometimes you have a flexible exception, which you fear will create chaos, but then if generative AI comes about, nobody has a problem in the US that it is fair and transformative use. If you try applying the TDM exceptions in the CDSM directive, that's still an ongoing discussion on whether they apply at all, even they are meant to be a much more circumscribed type of legislation. So I'm really tempted to take this further because it's one of my favorite topics, but I think I'll stop here. Happy to happy also to discuss it during the break.
Yeah, thank you very much. Also, since we have to stuck to the time, maybe one more question from the Slido, because we only have 10 minutes left.
Yes, my apologies that we didn't come to the Slido's questions earlier, but we will collect all of them and publish them and hope to bring them at least as an appendix to our documentation of the event. So there's one favorite now, the most first one. We have one GDPR in EU, but in practice we have different interpretations by local legal officers, which make things complicated. How to simplify this? But there are all kind of other questions. But this one is the one I would take.
Who wants to answer this question? Or who has a solution to this question?
I can only repeat myself. 2 lawyers, 3 opinions. I'm sorry about that.
2 countries, even more opinions. But I think the study that was mentioned now and that all of you are now Googling to find on the EU publication site is a first step into the direction of knowing what is out there, where simplification or harmonization would be necessary and what can be the priorities for it, right? So we need much more insights like the one this study provides to know where the different laws intersect and what we can also do maybe for in terms of the different implications these laws bring in on national level, for example. But as we need to close the discussion right now, I'm very sorry about that. I'd like to ask each of you one last set of questions, and you can pick out what you want from it. So with your backgrounds, what key legal priorities would you now kind of take with you, maybe also out of this discussion, to improve research data sharing within the context of EOSC also, because we of course haven't touched EOSC particularly a lot, but yeah, as you see, a lot to be done on the base layer. And what immediate actions or on the other hand, long-term strategies do you see as essential for advancing the effectiveness, but also the impact of data sharing in Europe and in the context of EOSC? What do you take away leaving this session? Please, Michael.
You put it in the context of EOSC.
Yeah.
Of course, this is about data storage, access and use, to use the same as the title of the study. It's about data processing. You need to be clear what are the rules and the obligations. It is about using EOSC also for cross-border research. And I think for all these, you need to have as large harmonization as possible, or at least for it to be predictable for the researcher and the research organization. And that comes along with user guidance, to go down to the practical level. It comes along with FAQs, to have some form of open desk or persons to go to. And it comes along with training, I think, of various persons. On the longer term actions, incentives and rewards is very important. The way we value research, the way we assess researchers, research organizations, research projects is key. And one of these criteria must relate to the value in sharing your data. So this is it's a longer term. We have launched the process already to reform the way we assess researchers and research projects, but it goes along with that. And as you said, this is a very good study, but we will be required to collect even more evidence of the impact of any legislative or non-legislative changes that we make, impact on the stakeholders, impact on the different markets, including economic impacts, and not only in the market terms, but also economic impacts on the efficiency and effectiveness gains in the research system.
A lot to do, a lot to do in one word. Irene, you want to have a final sentence?
I'm a huge fan of harmonization and standardization, but my experience is that bottom-up approach works better than top-down. So I'm rather not a fan of so many legislation. I would like to have the community coming together and putting up standards. We have been working on a code of conduct under GDPR for a while. Now we have EHDS putting another layer of complexity. It was meant to reduce complexity, but I was the one warning from very early on, this will be another layer of complexity. And now I think this is coming a little bit true. And then, yeah, we are, anyway, so many legislative acts coming out of different DGs on European level or different ministries on national level. From time to time leads to a little bit of confusion because definitions, come from one context and do not fit into another context. So we are then blamed as lawyers, say, oh, that does not fit. There's no overlap. But you as a lawyer, you should tell me how yeah, I can understand. I have no clue. Now we have 2 lawyers and 10 opinions. Yeah.
You've really been inspiring to our online participants as well, yeah. If you look at the last comment.
1,200 pages means 1,800 opinions. But if I may, so does that also mean, Irene, that we need more case law maybe, or that we need more, court decisions? The colleague has left already, but do we need more things that have to be fought out?
Maybe we have only one European Court of Justice, so the procedures are taking more and more time, and many people are not even aware of those decisions. We have a pending case on anonymization, very important, nobody knows it. We are creating standards on anonymization. We do not know the outcome of the European Court of Justice. Good luck then with the standards. Yeah, let's see.
Okay, and Casper, your takeaways.
If there's one thing that I learned from my policy years in Brussels is that complexity doesn't work. Because we live in times of permanent cognitive overload, and nobody has the capacity anymore to analyze complex frameworks. And when people cannot keep up, then bad things start to happen in many respects, and that's and I think we should dedicate a separate session to this during the next symposium. It's a long game, simplifying, harmonizing European copyright law for many reasons, as I'm sure you're aware. This is why initiatives such as EOSC are so important, because this is the approach that actually can work and can be achieved. So, fingers crossed.
even if EOSC is quite complex in itself sometimes, right? So thank you very much all. Thank you to the panel. Thank you to you audience for your intriguing questions, and thank you also to the audience on their screens. I hope these topics will be continually discussed in many, many outlets. I think a lot has to be done. And I really hope that also the Commission, as we heard yesterday by the Commissioner, how the Director as well, staying true to kind of backing all these efforts with the same power they have done so far. So thank you very much, and wish you a nice remaining conference.